Hi everyone, good afternoon. Thank you for joining our webinar, Work Visa Options After OPT. My name is Joseph Shepard. I'm one of the associate attorneys here at the firm, and I'm joined by senior attorney Avi Friedman. And we are going to go through and discuss what options exist after one finishes their OPT, including the life cycle from OPT to H-1B, what happens if the cap is reached and your application wasn't picked. And then we'll also talk about potential work-based green card options, and as well as other categories that may be options for those who didn't get picked. So I think that we can jump right in, and we're going to go back and forth between the two of us. And we ask that if you have questions, you can use your GoToWebinar question feature to type them to us, and we will try to address them here at the end. And if we don't get to your question, we will either follow up via email or we will incorporate it into our next webinar on point. So, moving right along. So, as most of you who are students in F1 know, there are several different ways to work prior to graduation. There's CPT and there's pre-completion OPT. There's also post-completion OPT, which gives you the standard 12 months of work in your field after graduation. You have to wait until you get the EAD card from USCIS to start working so that you can show it for I-9 purposes. You must apply within 30 days of receiving the endorsed I-20 from your school's designated, your school's DSO. And if you're working on CPT, then you don't need to apply directly for the EAD card. Your I-20 endorsed for work authorization fits the bill there. For those who are working in STEM fields, and that is the science, technology, engineering, and mathematics fields, and there's a specific list of these fields. It's not just, oh, I think my degree qualifies as one of these, or I think my degree doesn't qualify for one of these. There's actually a list that's maintained by ICE and SCVP, which you can access online, that has the updated specific fields. Those are the specific fields that are annotated on your I-20s otherwise. But I would check with your designated school official to see if your major or your program is actually covered in one of those. There's specific requirements that come with the STEM OPT extension that are not included in the regular 12 months of post-completion OPT. Your employer must specifically be registered with E-Verify. And that cuts out a lot of employers in states who are not required to use E-Verify, as is the case in Arizona. If they're not enrolled in E-Verify, STEM OPT extension not a possibility, and working for them will not be likely. But if you do get that OPT STEM extension, that can extend your total period of post-completion OPT up to 29 months. Which gives you another shot at next year's cap should the H-1B not work out this year or just not be ripe for your employer to want to follow through on. The STEM OPT, it must specifically be related to that degree program. There are rules for whether or not and how long you can be unemployed or underemployed. It requires that you work a minimum of 20 hours a week. Less than that is considered, not maintaining the full employment requirement. There's 90 days of unemployment allowed, and if you exceed that, then you can become out of status. If you're on the STEM extension, you get 120 days of unemployment. If you're worried about that, and if you're worried whether or not you're meeting that requirement, you should speak with an immigration attorney about it, who can go through and, document and ask for documents for each period. This also includes periods that you're not in the U.S. So if you leave the U.S. for a period of time, the clock may be running for you. So if you are worried about it and you don't have a job offer, you're in between jobs, and you don't want to reach that 90 days. You can also volunteer. That doesn't mean work for free, as a complete unpaid intern in a in a program that's typically not related to your field. It's volunteer in the more traditional sense. Nonetheless, there are rules about when you have to apply. Check with your school's DSO about the exact ones. 90 days prior to your program end date, so that's coming up, and we're in that period for a lot of you if your graduation is this spring. 90 days before, 60 days after, and the most important one too, 30 days within the date that the I-20 is issued. So if you get it from the school's designated, if you pick up that I-20 from your school's international office, you have 30 days to get it not just in the mail, but into the hands of USCIS. That is important, and it's worthwhile to apply for this. Even if you're maybe going to be going home, and don't wait until after you come back, maybe from a brief trip, within that 60 days after the program end date, or while you're in your period of grace after the end of your program end date. It takes right now between roughly 2-3, more realistically 3 to 4 months to get that card in hand, and you can't work until you have the card. So, apply early and apply, I think is the message here.
So in terms of what are your options, what we're going to do is start off with the non-immigrant visa categories and then progress on to green card options. And when we talk about the non-immigrant visa categories, a lot of our focus will be on the H-1B. That's sort of one of the main visas that folks progress to after completing their U.S. degree and finishing a year or longer on OPT. And so we'll start off with the H-1B, and the H-1B is called the Professional Occupation Visa. And so to start off, what is a professional occupation? By immigration's definition, the position must be one that requires at least a U.S. bachelor's degree or its equivalent to perform a specific position. And some examples, as you can see here, of H-1B titles that tend to be straightforward is a financial analyst, an accountant, an engineer, an account executive, an operations analyst, a computer scientist, software engineer, graphic designer, something like an attorney as well would be an H-1B. Where it gets more complicated are other positions where immigration may question whether a degree is required and whether a specific degree is required for that position. And that's really where you would want to be consulting with immigration counsel about, if you have doubts about whether a position might even qualify for an H-1B, that's something we can definitely look into and clarify. In terms of the H-1B, it is an employer-specific visa. So if you get an H-1B approved by a particular employer, it allows you to work for that employer only. It doesn't allow you to work for any other employer unless you get a concurrent petition submitted and approved by the Immigration Service. The H-1B can be for a part-time or full-time position. So you have the option there. If the employer is only offering a part-time position, you still could file for that application. The H-1B has a 6-year maximum, and you can apply in periods of up to 3 years at a time. So your first application would be for up to 3 years, and then you can file an extension for an additional 3 years. Most of the time, the H-1B is going to be at-will employment, absent an actual employment contract between you and the employer. So if for some reason you're not satisfied with the position, you can quit. Same if the employer is not happy with your performance or has other reasons for layoffs or terminations, they can fire you. The H-1B is a portable visa in the sense that once you've received your first H-1, if you find a new employer and you want to move to the new employer, you're portable and you won't be subject to the H-1B cap. We'll talk about the H-1B cap over the next several slides and how that works. So once you've got that first H-1B, and if you do find a new employer, you would be eligible to port, but the new employer is required to file another petition for you. In terms of the H-1B quota, every fiscal year, and that goes by the immigration fiscal year, which runs October 1 to September 30th, there is a quota in terms of how many H-1B visa numbers are available in that fiscal year. Typically what we're seeing is 65,000 for private industry employers are available in the fiscal year. Of that 65,000, there's several thousand that are reserved for H-1B1 for Singaporeans and Chileans, and you can see the breakdown there in terms of the numbers, 5,400 for Singapore and 1,400 for Chile, and most often those don't get fully utilized. There's also 20,000 that are reserved for U.S. graduates that have a master's level or higher degree. Now, in terms of timing, how early can you file for an H-1B? Well, generally you can file 6 months in advance of your start date. So if you remember, the fiscal year starts October 1, so the window opens up 6 months prior, which means as of April 1. Excuse me. Again, if you have an April 1 start date, April 1 filing date, the start date would be October the 1. So right now we are in the midst of what we call our H-1B March Madness, and unfortunately it doesn't refer to the NCAA basketball tournament, it's the H-1B March Madness. And the reason for the March Madness is we're in gear to get all our H-1B petitions filed with immigration during that first week of April. And what you can see here from our timeline, starting with fiscal year 2010, and between October 103 to 2009, there was a lottery for H-1B. So they reached more than sufficient applications during that time. And you'll see as the economy sort of declined for fiscal year 2010, there was quite a bit of time to get your application in, probably from April to December. Then the following year, the cap was only reached in January of 2011. 2012, it started to get shorter again. It was reached in November. 2013 was reached in June. And then you'll see picking up in for fiscal year 2014, the cap was reached that first week of April. And then last year, same thing, the cap was reached within the first week. So as the economy started to improve, more H-1Bs were submitted to the Immigration Service, and the cap was reached that first week. And we anticipate the same for this year, that in 2015, I think the numbers for fiscal year 2015 was something like 172,000 H-1B applications received. And when they receive that many, it goes to a computer-generated lottery. What is great in terms of if you file for the H-1B and you get selected and hopefully approved, is you're going to be eligible for what's called cap gap relief. And many universities and colleges cover what the cap gap means. We're going to go through it as well. So it applies to all F-1 OPT students who file their H-1B petition and get selected. So if you file your H-1 on or after April 1, your F-1 status will be extended if you were in status at the time you filed. Also, if you had a valid OPT, your employment authorization will be extended past the date that it expires. So for example, we've put together this chart here, and it sort of leads you through how H-1B cap gap relief works. So let's say you're graduating in a couple months in May, and you're applying for OPT, and your OPT would start as of July. OPT is going to be valid for a 1-year period up through July of next year. If you file your H-1B next year in April, and you get selected and you get approved, you would, from that time when your OPT ends, which is in July of 16, until when the H-1B would kick in, which is October 1 of 16, you have a gap. And so if you get selected and approved, your OPT will get extended, and you're allowed to continue to work during that gap. So between July of 16, your OPT expiration, through the end of September until October 1, when your H-1B kicks in, your OPT is automatically extended and you can continue to work. Now, what happens if you're not selected? Well, if you're not selected, you don't qualify for the cap gap. If your H-1B gets denied or it gets revoked, then you're not going to be eligible from the time of the denial or revocation. Your grace period would kick in from the time that you receive the notification from the Immigration Service.
And the nuts and bolts of the H-1B process, the first one here is very employer-driven, and it requires that the U.S. company that is making this job offer for the professional position files what's called a labor condition application with the Department of Labor to certify that they're going to pay the H-1B the required wage, and a required wage is one of the most important aspects of the H-1B process. The DOL takes about 1 week to certify the LCA after you file, but you can't file until the employer, and this is important for smaller or startup companies, that the employer makes sure that they verify their EIN or employer identification number with the Department of Labor. That's another 2-day process minimum before you can even file the LCA. The employer has to make some postings in the work site locations where the similarly situated workers will be to the H-1B. And once those are up, this can be filed with the Department of Labor. After a week, assuming that there were no issues in the LCA, it will be certified, and the employer then will sign and take appropriate steps to include a copy of the signed LCA with the H-1B petition itself, which brings us to step 2 with USCIS. Again, this is employer-driven. This will include more input from the foreign national, that's you, the student, to show that they are maintaining status. If it's a cap gap, to include evidence of the, in status at the time that the petition is being filed. If the OPT is valid at that time too, a copy of that card. And of course your evidence to show that you qualify for the position, your education and academic credentials. If you have any foreign education or academic credentials that are relevant, there needs to have included in there a equivalency determination and translation certificates if relevant. Everything then is put together with the petition and is filed with the USCIS. And since the cap, like we said, is opening up on April 1st, it's also important to remember that should the worst occur and you're not able to have the petition delivered to USCIS on April 1st, that the first 5 business days of April will remain open and they will accept petitions filed during that time for processing, and everyone gets put into the same lotteries regardless of which of the first 5 business days of April USCIS receives your petition. So just know if that FedEx deadline is missed on the day before April 1st, you can still get it in on April 2nd. Nonetheless, of course, you want to do it so that it's received on the 1st just to be safe and to have peace of mind. I made a quick reference to this with the LCA, but what do the employers have to do? What are they required to do here? They have to pay the required wage, and if there's no workers at the job site where the person will be working, the actual wage is what you'll be paying them. The required wage is either the prevailing wage or the actual wage, whichever is higher. If you pay software engineers at that place, say, $50,000 and the prevailing wage is $80,000, well, you have to pay them the required wage, which would be the higher of the two. There's no benching. That means you can't take a H-1B employee and park them on the side and have them not be paid. There's an exception to if a person makes a request for unpaid leave in writing and it's approved. H-1B workers are entitled to the same benefits as U.S. workers, and they're also eligible for things like FMLA. So bear in mind that if there are any issues that would require you to stop working, and especially stop working without pay, to make sure that the immigration counsel who filed the petition and your, of course, employer are all on the same page. And termination, what are the employer's responsibilities whenever the H-1B employment ends? Well, they have to pay the reasonable cost of transportation to your last residence abroad, and that has been interpreted by some administrative judges to mean one-way coach airfare. The employer also must notify USCIS immediately. Employers also must be aware that there is now a high level of chance that they will get a site visit from the USCIS Fraud Detection and National Security Directorate, FDNS, usually a few months after an H-1B extension is approved and or a petition for a change of status or a change of employer. One of these FDNS officers can show up and to the either place of employment or the company's principal place of business and ask questions and talk to you, talk to the employer representative. So ask and make sure that everyone's on the same page about what these are and how to prepare for them.
For those of you that have the entrepreneurial spirit, there is the option, and surprisingly many folks don't know about this, an H-1B for startup businesses. In the sense that you're going to pursue an H-1, as we've discussed, there needs to be an actual company, and that company has to have a tax ID number in order to file the application with the Immigration Service. Now, in terms of ownership of the company can be 100% owned by the person being sponsored for the H-1B position or the H-1B employee. But that employee has to be a true employee in the sense that they're on payroll, and at the end of the year they will receive a W-2. They cannot be a 1099 employee. There's also the concept that the company must be a separate entity from the owner/employee. So if you're the 100% owner, the company does have to be separate. And the way that immigration has authorized such a setup would be there must be an independent board of directors or another mechanism where there's control over this employee, and the employee can be both hired and fired. The company also has to show that they have the financial ability to pay the prevailing wage. They have to be able to cover the salary, and oftentimes if it's an entrepreneurial type position where the person's coming in an executive capacity, let's say as the president, CEO of the company, the salary is very likely going to be a six-figure number. The position must be a real position. It has to be an H-1B position. They'll also be looking at factors such as the business plan. If it's a startup, immigration will review the company's business plan, look at the financial projections. They'll want to see, very likely they'll want to see the bank account statements to show how the company will be able to pay the prevailing wage. If there's other employees of the company, that's going to be helpful as well, so that the H-1 being sponsored is not the only employee of the company, although it's not required. It's very helpful. Again, we talked about prevailing wage, where for executive type positions, the salary is very likely to be a high number. And with a startup business, having sufficient funds to being able to cover that salary for that 3-year period, if they petition for a 3-year. Also, the position must be a specialty occupation. So you have to be able to document how your coursework, your transcripts, do relate to that position.
All right. So, I think what most individuals at this point would be curious about is what happens once their H-1B cap season, once the cap has been met, what options are available? Well, for starters, and one that's, important and often overlooked is your employer actually cap exempt? Are they even subject to the cap? Do you have to, do the March Madness song and dance, or are you eligible to file your H-1B petition at any time? Institutions of higher education, colleges, universities that qualify, and the nonprofit organizations affiliated with them, nonprofit and government research organizations, would not be required to wait for the H-1B cap cycle each year. They are not subject to those limitations. And if you were previously employed by a cap-exempt organization but are now switching to a private employer, and that's important, you would then have to go through the April 1st, October 1st cap process. So it's like you've never been counted is one way to think about it. Once you're counted, however, that's it, and you don't have to, for example, for extensions, like we said, have to go through the process each time. So specifically, once you are granted your first H-1B cap subject, work authorization or visa, you get 3 years up to initially 3 years, and then it's extendable up to 6. If you've previously had an H-1B and you didn't use the whole thing, let's say you worked for 2 years and then maybe went back to school for a brief program, or you went home for maybe you were transferred to a different office for an extended period of time, you're actually able to recapture or collect the remainder of time left on your 6-year maximum. So that 6-year maximum H-1B time can run in the aggregate. So it's not limited to necessarily the October 1st, 2015 plus 6 years. It's actually the 6 years that you were in the U.S. in H-1B status. And if you're out of the U.S., say, for a month each year, then by the end of your 6 years, you'd be eligible to recapture 6 months of that time, and so on and so forth. If you're outside of the U.S., however, for more than 1 year, then you have a choice. You can either recapture or you can go through the new H-1B cap process. But there is that requirement that you're out of the U.S. For at least a year before you are eligible to be put back into the H-1B cap lottery like you would be initially. So I think we just went over this, but if other than the recapture, there are other ways to extend the H beyond the 6 years. The I-140 or the green card or immigrant visa petition, which is the next step. It would be what an employer would file, or what self-sponsoring individuals would file with USCIS as a step in the process towards a green card. If an I-140 or the labor certification for an EB2 or EB3 perm-based I-140, which we'll go through, has been pending for more than 365 days, then you can extend the H-1B in 1-year increments indefinitely until the green card process is complete. And if the I-140 is approved, but you can't make that next step towards either applying for the immigrant visa or adjusting status because your category is retrogressed, which we'll talk about as well, then you would be eligible to extend the H-1B in 3-year increments indefinitely until the process is complete. And in recent and exciting news, those spouses of, the H-4 spouses, certain individuals now are eligible to, will be eligible to apply for unrestricted work permits, or EADs, employment authorization documents, starting on May 26, 2015. If either the I-140 is approved or their H-1B spouse's petition was extended beyond the 6 years in one of those 2 ways I just talked about on the last slide. So that's called AC-21. If you have any questions about that, please speak with an immigration attorney about it. There are certain individuals who will become eligible for this. You cannot file yet. USCIS has made it perfectly clear that they will reject anything filed before that date. And H-4 children are not eligible for work authorization H-4 spouses and children can attend school in H-4 status.
So now we're going to talk about other alternatives to the H-1B. We covered in depth the H-1. And there's a few visa categories that are specifically based on your country of citizenship. And I had mentioned earlier the H-1B one, which is available for Chilean and Singaporean citizens. These applications can be filed directly at a U.S. consular post and do not need to be filed with the Immigration Service. There really is no, there is a cap on the numbers, but to date I don't believe that they've ever exhausted the numbers in a fiscal year. So you can basically apply for the H-1B one at any time. It is a more limited period, but you can keep renewing those types of visas. And again, the benefit is that you don't have to file directly with the Immigration Service. Then you also have the TN category, which is a category established under the NAFTA, the North American Free Trade Agreement, and that extends between the United States, Canada, and Mexico. So TNs are available for Canadians and Mexicans. There's a very specific list of categories that qualify for TN, and you can, if you search TN Appendix 1603 D1, you'll see the different categories. Similarly, for the H-1B ones for Chilean and Singaporeans, the requirements are very similar to the H-1B. You have a professional position. You are going to have a prevailing wage. So most of the things we talked about for the H-1B will apply for the H-1B one. For the TN, there's different requirements for each different position. So some, it's a straight degree. Others, they might allow a shorter degree plus some work experience. So it really depends on your position. Canadians, for the most part, are going to be visa exempt. So for the TN, you can either apply with USCIS, but since Canadians most often will travel back and forth at some point up to Canada, they can apply directly at a U.S. port of entry for the TN status. And the TN can be issued in up to a 3-year increment. The other, for Mexican citizens, they do require visas. So if they're going to be applying for the TN, then they would apply at a U.S. consular post. Then next, you have the E3, which is reserved for Australian citizens. And again, the requirements pretty much mirror the H-1B. It needs to be a professional position. There's a minimum wage. There really isn't, we don't have to worry about the filing for the cap. You apply directly at a U.S. consular post for the E3 visa. Next, we move on to the J1 visa for exchange visitors, and there's a lot of different categories. Most likely, after being an F-1 student and qualifying for OPT, you might be looking at the trainee or intern category. A couple of pointers, I guess, would be that it's going to be very difficult to qualify for a J1 after completing your OPT, especially if it's going to be with the same employer. The J1, similar to the F1, carries a 214B component, meaning you have to be able to prove that you will return back to your home country after completion of your program. And if you're in front of a consular officer or you're trying to justify this to the Immigration Service, they may not find it very viable that you just had an OPT where you engaged in training and you need additional training. So these are pretty difficult options if you've already completed your OPT. Now there is the J1 professor research scholar. A lot of times, depending on your country of citizenship as well, you might be subject to the 2-year home residency requirement. There is the H3 training visa. Again, the same caveat would be that after doing a year of OPT, the Immigration Service could question why you need additional training. Other visa categories include the L1A for multinational executives or managers, or the L1B for an employee who's got specialized knowledge. The key with the L1 category is that you must have spent at least a year abroad working for the parent, affiliate, or subsidiary. in either an executive, managerial, or specialized knowledge type position. So if you've been in the U.S. for the last 4 years for your degree, and you've been on OPT, it's probably not going to apply directly to you right now, but it might be a visa you might consider in the future. The L1A, you have a maximum of 7 years. The L1B, you get a maximum of 5 years. The nice thing about the L visa is spouses, or L2 spouses, can apply for the employment authorization document. Children are allowed to remain with the parents in the U.S. and can attend school but don't get work authorization. Also, there's a fast track for the green card, and that's the employment-based EB-13, and we'll talk about green card options in just a bit. Now we'll move on to the investor visa, which is the E2, that's the treaty investor visa, as well as the E1, which is the treaty trader visa. Number one, there must be a treaty between the United States and your country of citizenship, and you can take a look at the list of treaty countries online, and you can see the link on our slides at travel.state.gov. You can also just do a search online. If you search visa reciprocity, punch in the country you're interested in, and see if they, under the category E1 or E2, if it's available. The key is that the company must be owned by at least 50% owned by nationals of the treaty country. It could be a startup company, so it could be from scratch, or you can buy an existing company to qualify for either the E1 or the E2. For the E1, the key is that at least 50% of the trade must be between the United States and the treaty country. So for instance, it could be import-export, it could be a French national who's established a U.S. company and imports into the United States French wine. It could be any product, but the majority of the trade must be between the United States and that treaty country. Then you have the other option, which is the E2 investor visa. That requires a substantial investment. And what is a substantial investment? Well, nowhere in our immigration laws or books can we find a specific number. But generally, to have a shot in most countries of applying for the E2 visa, you're looking at an investment of at least $150,000 to $200,000. And it really depends on the type of business and what that business would require from an investment point of view. That's something that consular officers have quite a wide range of discretion in making that decision. For the E2 position, it can be the executive owner, it could be a manager, or an essential employee. Similar to the L visa, spouses and children get the dependent visas, and the spouse can apply for the work authorization.
Another common category and alternative for some individuals is the O1 visa for individuals of extraordinary ability or achievement. Individuals of extraordinary ability in education, business, science, or even athletics, or extraordinary ability in the arts, or extraordinary achievement in motion picture television fields. Those individuals may be able to have a employer or agent file the petition to classify them for O1. There's no cap on the O1 like there is for the H. O3 is the dependent spouse and children category. There is no work authorization for any individuals who are O3. O2 individuals are people who are essential support personnel who will be coming to work with that individual and have some experience with that person to a certain degree. But the O2s are limited to working with the O1 in the U.S. as specified. So we're going to go through this one in a little bit more detail. I think that this is one that we receive a lot of questions about, and so I think it's good to get some information out there. For the O1A, it is of the three, it is likely the highest standard. You have to demonstrate that you have, you're well known as one of the small percentage who have risen to the very top of the field. There's no real set percentage per se of what this means, but if you think about who has risen to the very top of the field, for lack of a better way to think about it, you could say, the top, 10%, who knows? I think that this is something that's very subjective, and it really comes down to the evidence, and what is the evidence that shows that you qualify. The O1B Arts is a little bit less of a reach for some individuals. You have to demonstrate that you are distinguished, you have a high level of achievement in the field, and have a degree of skill and recognition substantially above that ordinarily encountered. And then we have the O1B for motion picture television, which of the three is the lowest threshold, nonetheless still a high one comparatively. You have to show that you are well known, and you have a high level of accomplishment and achievement, skill, recognition, significantly above that ordinarily encountered. The regulations for the specific types of evidence that meet these standards for O1B Arts and O1B Film Television actually overlap. They're applied somewhat differently, but nonetheless, the language of those 6, you have to meet 3 out of the 6 for those 2, are the same. For O1A, you have a different set. There is some overlap. But here's some examples of the types of evidence that may be able to establish one or more of the required regulations. Often people come to us and say, I just graduated with my, master's, and I'm on my OPT now. I don't per se have a H-1B employer. I'm doing some work for myself. I have a startup, or I'm working for a very small company doing freelance things. What do you think that I'll be able to show that I have this O1? Well, for starters, right out of school, even if you have substantial experience in your field and are well known outside of the country prior to your latest degree, you have to take that into consideration, that USCIS discounts in a way, or does not give the same weight it does to things that were acquired or done while you were a student. And that doesn't necessarily mean that you can't use anything in awards or press or contributions you've made or things that you've written or things that you've produced while you're on OPT, but because it's so close to your graduation, you should consider continuing to build up your portfolio unless you actually are one of those individuals who would meet the criteria. Things that are helpful and are important are in the O1B context for individuals who have made, I've worked for some of the largest organizations and establishments on the most well-known and respected worldwide productions and events. That's great, but in that context, it would be extremely helpful to show as well that you will also continue to work for distinguished organizations, establishments, productions, and events. If you had your work displayed at exhibitions, that's great. Let's see, what's the reputation nationally and internationally of that festival or organization for which it was put on. If you've received high compensation in relation to others in the field, that is certainly something that can be helpful. If you have had your name on awards that you've received or that your team received for work in the field, that's great. Let's also take a look at what are the selection criteria for that award. Or if you've been invited to judge the work of others, that's fantastic. Let's also look at the nature of the selection process for that, and what are the reputations of those organizations that you've done this work with. Similarly with the publications, I have 20 publications. That is absolutely fantastic. Let's also take a look at what are the intended audiences of those publications. If it's professional journals, then we would want to, get the documentation from the journal that says that. If it is a mainstream media publication, information about the distribution and readership, these are all important things to think about, not just that it's about you and about your work and about your distinguished reputation and about your international acclaim and, specifically showcasing that you're one who's risen to the very top. Also, the weight of the evidence is important to be able to show as well. So think about that if you're thinking about an O down the road, that whenever you save a newspaper clipping, also maybe save the readership and distribution info.
So now we're going to move on and talk about immigrant visa options or green card. And we're going to talk about the DV lottery, we're going to talk about family-based options, and then we'll conclude with a summary about the employment-based green card options. So right off the bat, when we talk about the green card lottery, you can look at the requirements online at the Department of State's website, which is travel.state.gov. For the last year and several years going back, their Department of State and the Immigration Service give out close to about 50,000 green cards per fiscal year. And the way that the process works is it's a lottery. About 100,000 get selected for winning, but it's a race to the finish line, as they can only give out 50,000 or close to that. The registration period opens up the year before, so typically it's going to be in October through early November. There's actually no fee to put your name in the hat and try to register. You do have to be eligible to participate, and typically that requires at a minimum having a high school degree. So if you're in your U.S. university, you've got your bachelor's degree, most are going to qualify. It is based on your country of birth, not your citizenship. And you can take a look at, in the past, what countries were not eligible. And they're typically countries that have a high instance of immigration to the United States. So, for instance, Brazil, Canada, China, India, Mexico, Nigeria, Pakistan, Philippines, South Korea, United Kingdom, Vietnam. I left out a couple countries, but those are some examples of countries that are not eligible to participate in the DV lottery. If you're born in Hong Kong, Macau, or Taiwan, you are eligible. And you can also cross-charge to your spouse's country of birth. A lot of times you can access online the application if you do decide that you wanted assistance with the DV lottery. That's something our office does assist with, and we can help you with it. And remember, even if you are selected, it's a race to the finish line. There's a lot of rules and restrictions in terms of how to go about once you've been selected and you win. You still have to process either with the Immigration Service in the U.S. or the consular process with the U.S. consular post abroad to get scheduled for an immigrant visa interview, and that's something we can definitely assist with, whether it's just getting you registered, and if you do register and you win, if you need assistance with the immigrant visa application. The next option would be the family-based immigrant visas, and we'll talk about the different categories. The most common one would be the immediate relative category. So if you're in the United States and you meet that special someone and you get married and they happen to be a U.S. citizen, you're considered to be in the immediate relative category. Likewise, if you are the parents of a U.S. citizen or minor child of a U.S. citizen, you're in that same category. The nice thing about being an immediate relative is you can apply right away. If you're in the United States in status, or you entered the country legally with a visa and were inspected and admitted, even if now you're out of status, you can apply for adjustment of status. So if you get married and you're here in F-1 status, you could file for your adjustment of status. Your spouse would file an immigrant visa petition along with that, and it's concurrent filing. The nice benefit about it is within about 90 days from the time you file with the Immigration Service, you would receive an EAD, your work card, and also you can apply for a travel document, what's called an advance parole. You cannot depart the United States once you've filed that application with the Immigration Service. you have to wait until you receive that advance parole, with the specific exception of if you're in H-1B status or you're in L status, you might be able to travel if you come back with a valid visa. But it's always best to apply for that advance parole and apply for the EAD. Within about 4 to 6 months afterwards, you would get scheduled for an in-person interview where the immigration officer will interview you and your spouse, and what they're looking at is to make sure that this is a bona fide and legitimate relationship, that you married for love and not just for green card purposes. There's very serious implications if you marry just for the green card. There's both very steep fines as well as possible jail time if you engage in what's called a marriage fraud case. And you might ask, well, how is immigration going to know? These officers conduct hundreds of interviews every week, and they do have a good sense of who is and who is not legitimate spouses. And not only will they question you, but they'll also look at documentation to make sure that you maintain joint household type documents. If you're married for less than 2 years at the time you get approved for the green card, you're going to get what's called a conditional green card, and that green card will be valid for a 2-year period. At the end of the 2 years, immigration is looking to see that you're still married, living together with your spouse. If for some reason the relationship didn't work out and you end up getting divorced from your spouse, there still is options for you proceeding, and that's called a waiver type case. And that's our office frequently helps both straightforward type marriage cases and doing the removal of the conditions when you're still married, and if there is an instance where the relationship didn't work out, helping out with proceeding for the green card based on the current nature of the relationship. If you're a U.S. citizen and you want to file for your parent, the key is that you now have to be at least 21 years old.
Now, if there are, if you're related to a U.S. citizen but you do not qualify as an immediate relative, for example, if you are, your parents are U.S. citizens and you age out, you turn 21, then the wait times between being able to file the petition to qualify you as an immigrant relative and your actual ability to apply for the immigrant visa abroad or to adjust status turns into an extremely long wait. As of right now, the categories for individuals who are not immediate relatives of U.S. citizens but are qualifying relatives to some extent, the F-1, F-3, and F-4 immigrant visa categories, are backlogged very significantly. Right now there's an 8-year delay between the I-130s being approved and individuals finally becoming up to their place in line to apply for the immigrant visa or green card. That's an 8-year delay right now for unmarried adult children of U.S. citizens. Well, if that individual then gets married, that could, or if there's if that child is married whenever it's filed, there can be an 11-year wait. Similarly, for individuals who are children of lawful permanent residents, spouses and children of lawful permanent residents, importantly, and a few years ago this came up whenever that category became current for a few months, they are not considered immediate relatives to the same extent. So they're not eligible to concurrently file the I-130 and the I-485, for example, except for whenever the category is current, and it was only current that once, I think it was 2013. Now there's a backlog as they're digging out of all of the cases that were filed during that period. Those lucky enough to file during that period now have their, for example, in the U.S., if they're maintaining status when it was filed, their 485s pending and are eligible for employment authorization documents while they wait for this backlog to clear. However, the other categories are not so lucky. There's not been some forward movement on the categories to make them current in a very long time. As you'll note here on this chart, individuals who are unmarried adult children, that means they've turned 21, of green card holders, once they get married, there's no category that they would switch into For example, for U.S. citizens, F-1 to F-3, the F-2Bs, if that individual gets married, then they lose their eligibility for it. The longest wait line of them all is the brothers and sisters of U.S. citizens, the F-4 category. And some of you who were following the congressional efforts last year in the Senate bill that was passed would note that that bill would have scrapped this F-4 category. So, you know, right now this is the status, and we'll go into what these lines really mean in just a moment. Before I do, I want to talk about this quick category for individuals who are employment-based, for which there's currently no wait times. They're able to, right now at least, apply for the green card or immigrant visa at the same time as the I-140 petition, unlike the I-130s for the family-based category. That's called EB-1, and there's EB-1 through EB-5. We'll go through them each. For the EB-1, it's the priority worker category. Immigrant visas set aside for aliens of extraordinary ability, which is very similar to the O-1, but in the green card context, much higher standard, much higher adjudication hurdles to get through. Nonetheless, the same types of evidence may be used to meet these slightly different criteria to a different extent, but it can be considered in the same way that the EB-1-3, multinational managers and executives, is the fast track for an L-1 visa holder. The EB-1-1, aliens of extraordinary ability, would be the similar fast track category for O-1 visa holders should they have sufficient evidence. The EB-1-2 category is for outstanding professors and researchers. This is often in the context of individuals working with colleges and universities, showing that they've made, that they are, internationally renowned as outstanding in their respective fields. Those individuals don't have to wait to file the green card or immigrant visa applications along with the I-140. EB-1-1, I want to mention too, those individuals are able to self-sponsor and they don't require an employer, whereas the professors, researchers, and multinational executive and manager categories do require a U.S. employer to file the I-140 petition.
Now we'll also talk about the other employment-based categories. You have the EB-2, which is the second preference employment-based, and this is for folks that have an advanced degree. So this would be a master's or higher degree or a foreign equivalent, or a bachelor's degree plus 5 years of progressively more senior work experience. You also have the Schedule A Group 2 for aliens of exceptional ability in the art sciences or the art or performing arts, and then you have the EB-2, what's called the National Interest Waiver, or NIW. Then under the EB-3 category, the third preference, this is for a professional position with a bachelor's degree or foreign equivalent. Also could be a skilled worker with 2 years experience. And then there's a category which is considered other workers without a degree or without an experience requirement. Now, when we talk about EB-2, EB-3, EB-1, why does it matter? And what we're going to look at on the next slide is a chart which we refer to as the visa bulletin. And some countries, for different categories, will have what's called retrogression, meaning there's going to be a backlog in terms of when you can actually file for the last stage for your green card. And most likely, the most impacted countries do tend to be China and India, although Philippines also sometimes will have backlogs as well. So if we look at every month, the Department of State publishes what's called the Visa Bulletin. And again, I refer you to that travel.state.gov. If you do a quick search for Visa Bulletin, you'll find it. What you're seeing here is the chart for the 2015 Department of State Visa Bulletin. And they have these charts for both the employment-based and the family-based. You can sign up at the Department of State website, and they'll email you every month the most recent bulletin. And what we're looking at is what is your priority date, and typically that's going to be the date of filing of your application with the Department of Labor, your perm filing, or if you file with the Immigration Service, the date you filed your I-140 immigrant visa petition. And you can see for the first preference category, the C means that it's a current. There's no backlog, so all countries are going to be current. For the second preference category, you'll see for most countries it's current, but you have significant backlogs for folks from China and India, and most significantly for Indian citizens back to January 1 of 07. The third preference, we have backlogs across the board. June 1 of 2014 for most countries. For China, it goes back to October 22nd, 2011, and then for India, it dates back to January of 04. So you can see that right now, India is the most backlogged from a citizenship perspective. And the reason for the backlogs is Department of State allocates a specific amount of visa numbers per year for the employment-based categories, and it also has per country limits. So that's why you're seeing these backlogs for certain countries. Now, the importance of retrogression is you can't file your final stage of the green card, meaning the adjustment of status, or if you're abroad, you can't consular process and be approved for your immigrant visa until that priority date is current. And we're going to go through the details and the steps of what's involved in a typical employment-based process.
So here's an overview of this three-step process that we commonly refer to. This is this comes up most in the, actually, only really for the perm-based EB2 or EB3. And it starts with, and similar to the H, how I started with the concept that it's employer-driven. In the perm-based EB2 or EB3, it is exclusively employer-driven, and the company will conduct a good faith recruitment process to determine whether or not there are any qualified, willing, and able U.S. workers for the position. This also requires obtaining a formal prevailing wage determination from the Department of Labor. There are similar requirements for the wages. The company will have to demonstrate it had the ability to pay the required wage throughout the perm process, specifically once the perm is filed with the Department of Labor. Now, this is a long process, much longer than the H-1B, where we were talking about a number of days for preparing and filing. In the perm-based process for a immigrant visa or green card, the perm, once it's filed, and it can take at least 2 to 3 months for the prevailing wage determination, at least 60 days, but no more than 180 for the actual recruitment and quiet period. And then once it's filed, it can be right now 7 months, maybe 6 if you're lucky. However, 1/3 of perms are subject to audit or supervised recruitment. That's about a fourth or a third. And those delays can extend the life of step 1 from around a year plus to 2.5 years potentially. Once the audit or supervised recruitment notice is sent, the employer will have roughly 30 days to respond, and then the Department of Labor will take a couple months, if not a year or two, to review and issue either something else or a decision. But nonetheless, that happens in only about 1 in 4, 1 in 3. Once the perm is certified, it will allow the employer that filed or that is filing the I-140 to proceed to step 2. Now not necessarily the H-1B worker, but the foreign national employee who the job is being offered to will be involved in this process as well to demonstrate they are qualified for the position being offered. The I-140 process is much faster than the perm. There is premium processing available with USCIS, and this can take anywhere from, once filed, 15 calendar days to, if there's a request for evidence, upwards of 4 months. Once the I-140 is approved and you have an I-140 approval notice in hand, for those individuals who have been on an H-1B, that can be helpful for extending past the 6-year mark, as we said, because of the visa bulletin delays in being able to file that next step, step 3, the adjustment of status or the immigrant visa application abroad. Once step 3 is filed, however, depending on how long that takes, the individual will also be able to concurrently apply for work authorization and travel authorization. And now the travel authorization allows an individual with an application to adjust to green card as opposed to change to another letter or of the non-immigrant visa categories, allows them to travel without triggering an automatic withdrawal or denial of their application to adjust. Now that does not apply H-1Bs and Ls because they're able to travel by operation of law without triggering that. But for other individuals in other statuses, it's important that they remain in the U.S. if they did an application to adjust and not depart until they have some advanced permission or advanced parole to do so. Speaking of the specific perm issues and whether or not to file in the EB2 or EB3, obviously, as you see here, individuals in pretty much every other country would want to file in the EB2 just for the sole purpose that it's current right now and there's no wait time. However, that's not up to the foreign national and what their educational backgrounds are. So keep that in mind if you're thinking about this in the future. I also want to take this moment just to clarify that this green card process is not necessarily a substitute. It's if you are filing in an EB2 or EB3, and I just explained how long these steps are taking at the outset, you still, if you want to be in the U.S. during those steps, you would have to have some valid non-immigrant status underlying it. And if you want to be working, some valid work-authorized non-immigrant status. Or if you were lucky enough to be able to file an adjustment and have work authorization that way, fantastic. But nonetheless, you have to be here in some lawful stay if you want to be able to avail yourself of adjusting once that step 3 becomes possible. So keeping that in mind, it's not like the H, for example, that, oh, I qualify for this, so it's fine, I want to be able to do the EB2. Well, it's what are the minimum actual requirements for the job. If the job only requires a minimum of a bachelor's degree and you have a master's, fantastic, you're still qualified, but because the job only requires the bachelor's degree, the petition, the I-140, can only be filed in the EB3 context. Some specific things to keep in mind with the perm, and most importantly, is that the minimum job requirements can't be tailored directly to someone's experience or education. If you're narrowly tailoring the job requirements, A, you shouldn't be involved in this process to begin with, but B, if an employer is doing so, that could be a sign of bad faith recruitment, let alone fraud or misrepresentation issues. So it has to be a good faith recruitment effort. The job requirements can't be tied or really restricted to something that is so absolutely clearly you. And trying to just add on foreign language requirements don't work either. If the job actually does require foreign language, for example, if it's a teacher at a bilingual school or a individual who is doing market research or analysis specifically in that country or dealing with clients specifically in that country, and there are travel requirements as well, or for example, interpreters. Those are types of things where you can use this, but an employer can't jump in and say, the candidate here is bilingual in English and Portuguese, so let's make that a requirement. No, I mean it's what the actual job requirements are. And then also, very importantly, employment experience to meet maybe, for example, an EB2 versus EB3. As we mentioned before, bachelor's plus 5 years of experience. Not only does that, number one, trigger some issues about whether or not and what prevailing wage would come as a result, or whether or not it's excessive for that occupational category. You can't use a foreign national's employment experience with that petitioning or sponsoring employer on the perm. There's an exception to that if those two positions, the one that they gained the experience in and the proffered perm position, are more than 50% dissimilar. And that's a really complex issue that we won't get into on this webinar. Nonetheless, if you have specific questions about it, please jump in and let us know. Also, any employment that's in the U.S., it cannot be unauthorized if you're trying to use it. When would someone start the green card process? And as I clarified previously, this is not a substitute to the non-immigrant visas or work authorized status. This is the next step or adjustment to green card holder. As you saw, there's no lifetime limit for a green card, but there is for the H. And so if you wanted to work past the 6 years and you didn't qualify for any other non-immigrant visa categories, which, by the way, have various and different and important to consider restrictions on immigrant intent and or maintaining a residence abroad, then adjustment or applying for an immigrant visa and thus a green card would likely be in your best interest. So most employers, just anecdotally and in our experience, would likely start the green card process and sponsorship for an individual at around the 3-year mark. It's best not to wait any later than that 4.5 mark once someone's into their H-1B, because then you'll get into issues like if the step 1 is audited, the perm is audited or receives a supervised recruitment notice from the Department of Labor, you may not be able to finish the whole process before your H-1B expires. You certainly don't want to wait until the 5-year mark for someone who's an H-1B and they don't have any recapture time, because it won't have been pending for 365 days or that year to allow you to extend the H-1B in 1-year increments. So around the 3-year mark, in our experience, is about right. And that's also true for individuals who maybe ask their employers about it. They want to be sure that they like the employer. The employer wants to be sure that they like the employee. Also, for individuals who have been working for a company for a few years and then maybe move to another company, they would wait and see if they like that company too. They also may have an added benefit of being able to use any qualifying experience that this job required, that they weren't able to even apply for it until they got there. Another important consideration, and this is going to be my last one on this point, is that the proffered perm position doesn't have to be the person's current and right now position. It can be a future position, and it can be a position for someone who doesn't currently work for your company. If you're going to employ them, indefinitely once they become a permanent resident, if you're going to make a permanent job offer to this person, you can do so, and that can still process even if they're working for someone else at that time, and vice versa.
So the last two categories for the employment-based visa options, we have the EB4, which is the religious worker visa category, and then we have the EB5, which is the $1 million investor green card. And you have the option under the EB5. It's either going to be $1 million investment or it's going to be $500,000 if it's in the area of high unemployment. The key to the EB5 is that the investment, not only is it a money investment, but you must create 10 direct jobs. The jobs can be indirect if it's in a TEA, or what's called a targeted employment area, or a rural area. Within the EB5, there's also what's called the regional center program, the regional programs. and typically those are going to be in the lower range, the $500,000 range. And in the regional centers, there's many different types of opportunities. You have everything from real estate to hotels to ski lodges to almond farming to wineries. There's many different companies that are qualified for the regional center program. And from the investor's point of view, it's up to you to do the due diligence and make sure that it makes sense from a financial perspective. From the immigration law's point of view, we assist with processing the green card. We don't give advice about what's a good from a finance perspective, but we can definitely help from the immigration perspective. Under the regional program, you have the loan or equity models, and the steps that are included in the EB-5 is the initial petition that gets submitted to immigration. That's the I-526. Once that gets approved, you then file for your adjustment of status, or you could do consular processing if you're abroad. Similar to the marriage-based green card that we talked about, you get a 2-year conditional green card. At the end of the 2 years, you file the I-829 to remove the conditional aspect of the green card. So that concludes the summary of the employment-based immigrant visa green card options.
All right. So thank you all so much for your attention and your questions. We do have a couple of them that have come in, and we do have a little bit of time left to go through some of them. I appreciate, again, the questions and your attendance. And if we don't get to your question, like I said, we will be happy to follow up via email, or we'll cover it in our next webinar. So if you don't see the answer here, you can either reach out to us directly, or you can attend also the next one coming up. The first question here we have is regarding whether or not you can switch between OPT, the 12-month, or go straight to the STEM OPT. That's a great question. The STEM OPT extension application process is somewhat different. If you felt like and wanted to go straight for the initial, I don't see that as being a complication, but I would also say that it's the path of least resistance is usually the one that you should go with, and if you have the 12-month to be able to work that way, that's what I have commonly seen. Avi, do you have anything to add on about that specific issue?
I would just say, you're better off with the 12-month OPT in any event because there's no E-Verify requirements, and typically, you have to be able to prove, and the employer must be E-Verified. So that would be my comment there. And again, it's something that, the OPT side of things, that's really a question that you would discuss with the International Student Office as well on how and when they can authorize the different types of OPT.
We have another question. If I'm currently in F-1 status and I have an expected graduation of May 2016, and if I find an employer willing to sponsor the green card now, would that process harm my F-1 status now? I think maybe that has to do more with determinations of your non-immigrant intent whenever those need to be adjudicated, and I think that comes up often in travel. What do you think about that, Avi? About someone who has an employer in the green card process for them, or rather a future employer, but they're in F-1 now?
Well, I agree. I mean, if the person is going to remain in the United States, it's probably not as much of an issue. But in the sense of when you travel, whether you have an existing F-1 visa that's valid, or if you're going to travel abroad and need to apply for a new F-1, one of the questions on the DS-160 is, has anyone ever filed for an immigrant visa petition for you? And the second you tick the box yes, that's very likely going to come up at the interview, and the consul might deny the visa application on the basis that you have the intent to immigrate permanently to the U.S. even if you have a valid F-1 visa, when you come in at the U.S. port of entry, Customs and Border Protection, CBP, can also ask the question, and if they don't feel that you have the intent to go back home, they can cancel a valid F-1 visa and send you on the next plane home. So, filing for a green card can definitely impact travel. Within the U.S., it's less likely of an impact. Again, this is something the specifics should probably be worked out with an immigration attorney in terms of your travel plans and the ability to make that work if you do decide to just remain in the U.S.
We have another question here about same-sex marriages. Do same-sex marriages lead to, and can they lead to, family-based immigrant visas? The answer to that is yes, in general. Same-sex marriages that are valid where performed, the place of celebration rule is what is the law for immigration. If the marriage was valid where performed, regardless of the sex or gender of the two spouses, then absent fraud or bad faith or some other type of public policy consideration that would arise to something like crime, and that does not mean same-sex marriages. I'm specifically talking about the place of celebration rule. As long as it's valid where performed, regardless of where those individuals live, USCIS will recognize it. And that can be true for immediate relative-based petitions, for F-2 petitions for spouses of lawful permanent residents. Ever since the Defense of Marriage Act fell, the Department of Homeland Security was very fast and very helpful in training their staff and adjudicators to recognize these issues. Every now and again there are some hiccups that come up, and this is also true for the fiancé visa. As long as the individuals are intending to marry in the U.S. In a state that where it will be valid where performed, then it would be valid for immigration purposes. So yes, to answer your question in short, and also to think about that too, for prior to the fall of DOMA, whenever people were in a category of unmarried adult sons or daughters of lawful permanent residents, and thus whenever their marriages now were recognized, were catapulted out of that category and now don't have a category. So there are a few individuals who, while they were not recognized as married previously, are now. Another question we have here is, I graduated in December 2014, and my OPT started in February 2015, so it's valid until February 2016, assumedly. Can I file for H-1B next year if I miss the April deadline this year? If your H-1B is not selected in the cap or you just don't meet that deadline for this year, if your OPT will remain valid until either notification or the expiration date of your OPT, whichever is later. Then you get a 60-day grace period. So if your OPT expires February 2016, well, then it will not be current. You won't have OPT come April 1st, 2016. You may, depending on when in February, likely you will, but in February, if your F-1 program end date is your OPT, you have 60 days after that. So your F-1 could be extended. Your OPT would not be, because it was not expiring between April 1st and September 30th of that year. So you would be able to physically remain in the U.S. but not work, assuming that it was selected in the lottery and approved until October 1st, 2016. Now that doesn't mean that you can't have the petition filed. That has to do with your ability to remain in the U.S. and work until then. There's no requirement that you're in the U.S. and working while an H-1B petition is pending, but if you need to or want to, and the employer wants you to, there is relief available during that gap. Avi, do you have anything on that to add?
No, I think that's completely accurate. I agree.
Cheers. And there's one last question here that we have, and then we will call it a day. Yes, there is MCLE credit available for this seminar. For California, we are an authorized provider. So if you would like to get the required documentation for that, please email Avi or I. And thank you very much for attending, and we appreciate it, and we'll see you at the next webinar.